Hey everybody, welcome to the Friday edition of Live at 5:30. I'm Mark Hebscher.
And I'm Donna Skelly. We continue tonight with a special in-depth discussion on the story we broke yesterday regarding the 11-year-old Hamilton boy forced into cancer care against his and his family's wishes.
Now yesterday we exposed the tragic story of a Hamilton family caught in a life-and-death struggle with authorities. Their cancer-stricken son was forced into receiving treatment he and his family decided not to take advantage of. The father was forcibly removed from hospital when he objected. The response to that heart-wrenching interview has been overwhelming and overwhelmingly in favor of the family, while being deeply critical of the actions of the Children's Aid Society.
The question our viewers are asking is, how can the CAS do this? Is there no recourse? Why isn't there some level of oversight by authorities? We're going to spend a major portion of today's show trying to answer those questions.
And we're joined on the telephone by John Dunn, the Executive Director of the Foster Care Council of Canada. In studio, Gordon Morton, one of the Deans of Family Law here in Hamilton. As well, we have Michelle LaFantasy, a Dundas mother who has long called for oversight of Children's Aid Societies, and at Queen's Park, NDP House Leader Peter Kormos. Peter, you first. Does the government need to legislate some kind of watchdog to specifically deal with Children's Aid Societies in Ontario?
We've got to go far beyond that. Children's Aid is out of control. There's absolutely no accountability whatsoever. The government has refused to enact legislation that would give the provincial ombudsman oversight capacity vis-a-vis Children's Aid, Family and Children's Services. Let's understand this is a private corporation, a private organization. It's not a part of the government. No accountability. I say it's time to shut it down. The government should be directly delivering child protection services.
Wow, that's a tough statement. John, people have been upset by what they see as CAS heavy-handedness in this case. Did child authorities have any other options available to them other than simply getting a court order to gain control of this child?
Well, there was legislation that was passed a couple of years ago, Bill 210 it was called, where it changed the Child and Family Services Act. And one of the changes is that under Section 20.2, it offers what they call alternative dispute resolution process. And by the way the legislation is worded, the society has to consider whether they can enter into, or whether, you know, an alternative dispute resolution would assist them in resolving any issues related to the child. And so they could have entered into that process. Now, whether or not they did, I don't know. But it doesn't appear to have by the speed at which this whole thing took place.
All right, Gordon, we should clarify a legal point here. Does the affected family have to be presented with a court order before a child is taken into custody by child authorities? Because according to the family, that's not what happened.
Well, I've tried to dig around and get an idea of what happened here, and as much as I can figure out, first of all, the doctor has no choice. Once he asks the parents, I wish to do this medical procedure on your child because it needs it, it's life-threatening, or harm will come if I don't do it. If the parent refuses, the doc has no choice but to pick up her phone and notify the Children's Aid Society. At that point, the Children's Aid Society becomes involved, and I can tell you, if the doctor doesn't do that, she's subject to criminal sanction. Just as I, as a lawyer, if that comes to my attention in the law office that there's child abuse going on in a case, I have to report it.
But you're calling that child abuse. I guess the real question here is if both parties, that being the child and the parents, decide that they don't want to continue treatment, why is that deemed child abuse?
Well, I'm sorry, I'm using the wrong term. The child is viewed in need of protection under the statute. The child is in need of protection if the parents refuse a medical treatment that's likely to help the child.
Michelle, we seldom hear of cases like the one in Hamilton which centers on medical treatments, but you say that this actually happens quite often.
It does. It happened last year. A woman that was in Press in Brampton, I believe, wanted to try alternative medicine for her child and was forced into, from the same hospital, into care. The CIS came along. It turned out in that case the child was given the wrong type of care and transferred herself and her child out to sick kids who used a different protocol for the child's care. Can I interject here?
Yes.
I think of a child's life as not an imminent harm. And there are better ways to handle these things than to call police and call Children's Aid. Surely the hospital has tools at their discretion and staff and psychologists that can help a family through a difficult position like this.
Okay. Folks, I want you to hold these thoughts. We're going to take a short break and we'll continue this 5:30 panel discussion. Welcome back as we continue to delve into this story behind the forced hospitalization of a cancer-stricken boy from Hamilton. Our focus today, the power of the Children's Aid Society. We're joined on the phone by John Dunn, the Executive Director of the Foster Care Council of Canada. Here in studio, Gordon Morton, a lawyer, one of the Deans of Family Law here in Hamilton. Also, Michelle LaFantasy, a Dundas mom who has long called for oversight of Children's Aid Societies. And at Queen's Park, we have NDP House Leader Peter Kormos. Peter, governments have been loath to make substantive changes to the child services system in this province. What do we need here, a major overhaul or minor tweaking of the CAS?
No, we need a radical new approach. We've got to understand that the history of Children's Aid goes back to almost the Victorian era, when governments didn't want to do child protection and were prepared to farm it out. Those days are long gone. Look, we want child protection authorities to have some significant powers, but we also want standards, guidelines, and strong oversight and transparency. We don't have that with the Children's Aid. You've got a very sick kid here with a deadly disease, undergoing a treatment that is in and of itself is a very painful, exhausting treatment, and Children's Aid scoops the kid and takes him from his family. Children's Aid should be working to make sure that kid's with his family, enjoying what support that family can give him. This situation is nuts, but the problem is it's not unique. Similar situations take place across the province. There's no consistency from community to community, and there's no accountability.
John, do you think that the solution is accountability in the way of having a government-run agency, government-controlled agency?
Well, I think that would be definitely beneficial because all the other, like being a private agency, I've tried other measures of accountability using the Corporations Act, and you know, they just hire lawyers to, you know, to fight back and everything. So everything you do comes down to nothing happens. So at least with the government, there would be procedures in place and accountability through either the ombudsman or just through the government processes itself and the legislature.
Gordon, is there any way that young kids who haven't reached the age of majority would be allowed to make medical decisions affecting their own lives?
I don't see that. One of the things I do know about this case is that the Office of the Children's Lawyer appointed a lawyer, a very experienced man here in Hamilton, to advance the interests of that child. So from what I can gather, I think all sides were heard from, and everybody had an opportunity to make full answer and defense to any allegations raised, and then the judge made his or her decision, and that was followed through.
From a legal perspective, are you concerned that this has set a precedent that parents now will be very worried about having any influence over the treatment of their children?
Well, it's not set a precedent because this is, as Michelle has mentioned, it happens all the time. Every time a parent turns down a reasonable medical procedure, the hospital and the doctor must, I underline must, get the Children's Aid
Except
involved.
you're calling it reasonable. The parents were suggesting perhaps it was not reasonable, and that's where I have a problem. I find it such a gray area, and it's up for interpretation. It's a subjective word.
Well, one of the problems we have, of course, is that this is not an open court, to the extent that
you don't know the facts.
Yeah, you and I are allowed to attend there, but the problem is we don't know when the case is, and the names are not disclosed. That's not to say the press has been shut out of this. The press can go, and the press, if the court permits, report on the proceedings.
Michelle, you wanted to add something here?
I also think the court tends to, with all due respect, rubber stamp what societies want, and there's an awful lot of over-deference to the medical profession in law in general, as we can see by the inquiry we've just had with Charles Smith. We need to really step back and think about what we are doing, and to take a child from a loving parent while he undergoes chemotherapy and invasive process, to me, makes absolutely no sense at all.
Yeah, that's certainly, you have agreement on from all parties on that respect. That was something that we are all very upset about, and we'll continue to follow this story. Thanks so much to our guests today, John Dunn, Gordon Morton, Michelle LaFantasy, Peter Kormos. Thank you all for joining us. Have a good weekend.
Thank you.